Thank you for joining us this Monday. My name is Bruno. Edgard, as always, Issues at Hand comes to you here on Church of Uganda Family TV and is brought to you by Protea Hotel in Tebe, where you can find yourself being relaxed and getting and meditate on the word near the lake shores. Now, Issues at Hand is a provocative show in which we discuss certain issues that are prevailing in our society, and Issues at Hand is always for our family and for our viewers. So please feel free to get in touch with us. Send us your comments or your questions on 0787 447 684. 0787 447 684. We want to hear from you, and today we are having a very interesting discussion, especially for you who is a worker. Yes, we are going to talk about workers' rights, the plight of workers, and we're going to talk about how workers can be sensitized about their rights. What are some of the rights that we need to know about when it comes to workers' rights? So you don't want to go anywhere. Keep it locked here on Church of Uganda Family TV. Now, my guest for today to discuss this issue of the plight of workers is Miss Bwiite Lydia, and she is the Director Programs from the organization called Platform for Labor Action. Bwiite Lydia, you are very welcome.
Thank you so much, Bruno. Thank you so much, Bruno, for inviting us to the Family TV. My name, once again, is Bwiite Lydia. I work as a Director of Programs at Platform for Labor Action. To our dear viewers, it's your very first time to hear about Platform for Labor Action. Sorry about that. Yeah, I don't know if I was heard. Maybe I could just say, but once again, my name is Lydia Bwiite. I work as Director of Programs at Platform for Labor Action. And to our dear viewers, Platform for Labor Action is a non-government organization that advocates for the rights of vulnerable and marginalized workers in Uganda. And when we talk about vulnerable and marginalized workers in Uganda, we're looking at those workers, the low-cadre workers, the workers that some of them are undocumented, workers like domestic workers, workers like street vendors, market vendors, low-income earners in terms of workers. And you know, Bruno, in this country, almost everyone is becoming a low-income earner because the wages, in most cases, we earn hand to mouth. So the low-income earners. And why do we target them? Because we believe that such kind of workers, like I said, like domestic workers, for example, these are critical workers, first and foremost, but they are not well documented. Their rights are not well emphasized. Like me and you were a bit protected because people see us entering an office, and therefore the presumption is that you have rights accruing to you. You also have responsibilities. But workers like domestic workers, their rights are not well documented. But also society, it has a negative bias towards them not being viewed as workers. So what do we give them as workers? We give them legal representation. Platform for Labor Action, our dear viewers, is also accredited by Uganda Law Council to provide legal aid services to such workers. So we give them legal aid. We do awareness raising using different platforms. Like today, we are using Family TV to raise awareness. We go to radio stations, we go to the community, we go to the workplace, we work with the workers, we train them. But we also do what we call advocacy on issues affecting these kind of workers that we represent. It could be local level advocacy, but also national level advocacy. Advocacy targeting, let's say, legislation, maybe to ensure that maybe it is amended or it is enacted so that such workers are actually protected. Advocacy in terms of change of treatment of such workers. But we also engage the employers, the private sector, because we need each other. You need the employer, but also you need the worker. So we believe that this is a relationship that one needs the other. You are employer, you have so many things to be done. You need workers there. But often, what we realize is that in most cases, our employers take the labor, in the factors of production. Labor is one of the factors of production, but they just look at it as a mere factor of production. They don't look at it as an engine of production, because without that labor, nothing would be done anyway. So we try to balance that relationship between the worker and the employer in terms of so reaching them, sensitizing them as well. So in most cases, that's what we do. Representation in court. When we say legal aid, is free legal aid services that we give to these workers, because we know that they earn very low. You find like a domestic worker earning 50,000 shillings a month. So just imagine if they had a case against the employer. You know the litigation, the legal processes in the country. Such workers cannot afford legal representation. So we give them legal representation, and that's why we are accredited by Uganda Law Council to be able to give them legal aid services. Yes.
Wow, that is wonderful, and we shall find out more about what you do. Now, on this discussion of workers' rights, what exactly are workers' rights?
Thank you. First and foremost, to our dear viewers, workers' rights come from, or they start from the point that we have an employer and we have an employee. So once there is that relationship of employer-employee, there are rights that accrues to the worker, and there are also responsibilities that come to the same worker, meaning the rights of a worker become the responsibility of the employer, okay? And then the responsibility of the worker become what is expected of them, okay? Hopefully I've not confused us. But once we have an employer and an employee, then we have rights that come. The first right, why do we go to work?
To earn a living.
Good. Yes. So the first right that we have as workers is the right to be paid, our wages, our pay. That is a right, and that right has different connotations around it. I have a right to be paid as agreed. If we agreed 50,000, please pay me the 50,000, and I have a right to be paid within the time frame that has been agreed upon. If I'm to be paid after finishing that work, that is, if I'm casual, for example, and I'm supposed to be paid at the end of that work, I should be paid. If I'm a monthly earner and I earn at the end of every month, then that time when it comes, I should be paid. So right to be paid comes with, I should be paid the right amount of money that we agreed upon. I should be paid within the time that we agreed upon. And that right to be paid also comes with the fact that we know that there are what we call deductions, lawful deductions that can be removed from my salary, me as a worker. As a country, we have taxes that we pay even as workers. So we have what we call pay as you earn, or employment income. So pay as you earn is depending on the threshold of how much you're earning, because there we start at 230. Such a person should be able to start paying pay as you earn. So you remove whatever I'm supposed to pay lawfully. NSSF to be deducted 5% from my salary that I'm earning, and then of course you remit it there. So that right to be paid, pay me anytime as agreed, and only remove lawful deductions. Why am I emphasizing that? Because we have scenarios where employers make unlawful deductions from people's salaries. Let me give you an example of a worker, like a domestic worker. So when they break a plate, someone wants that person to pay for that plate. But then, unless it is in the contract that if you destroy my properties, I have then to deduct from your salary, okay? And some of these workers face these deductions that they're not very clear, because in most cases workers don't even have a contract. So someone just wakes up and say, oh, we deducted this amount of money. For what? You can't tell. So the first one number right is the right to be paid, because that's the only reason why I wake up every morning. You wake up, people wake up to go to work. It's the first right. The second right is I have a right to rest well at work. Like that 1 hour of lunch that we get, it is our right to be able to rest, because we just want you to. The lawmaker thought it right that a human being cannot work continuously without that particular rest. At least that break at that 1 hour, it's a right to rest. And if the work is going to work continuously, then you should be able to compensate them for that particular 1 hour they have worked, which is their entitlement. So that is a right. because you find that some workers employers don't want these people to rest at all, and yet it is a right. It also comes with health benefits, like this worker just to take a walk and stretch and all that. So it has health benefits as well, but it's a right that someone has. The other right we have, like right to annual leave. Okay, the law gives us 21 days of annual leave, that every employee is entitled to annual leave of 21 days. Like again, it is to go and sort of like refresh yourself and come back when again you're refreshed and you are ready to go. So 21 days. If because of the work schedules I'm unable to go for my leave, then my employer should be able to pay me in lieu of the leave. The word lieu is so, but instead of my leave, okay? Instead of me taking my leave, then you pay me. That's an equivalent of 1 month's salary, because 21 days we don't put in the weekends when we are counting them. So that is the other right. And that right, just speaking to the workers out there that are watching us today, is that you have to work hand in hand with the employer, because there should be a schedule, okay? The employer has to put in place a schedule of the leave, how someone takes the workers take the leave, so that then you don't leave a vacuum at the workplace, or when production has come to a standstill. So it is always good to be able to speak to the employer so that you are able to. And I'm encouraging workers out there, please apply for your annual leave, because right now, the industrial court, if you say, let's say if they have terminated your contract and you go and say, by the way, for the last 8 years I've been working there, I've not taken my leave, therefore they should pay me. The first question they ask you as a worker, what steps did you take in ensuring that you take this right? Did you apply? So you should be able to have evidence that indeed I applied for my annual leave, but maybe the employer was either adamant or just failed to comply with the labor standards and I did not go for that leave. So right to leave is that one. The other right I like talking about is the right to maternity leave. Now, for every female employee who has been employed, and by the way, this right knows how many days I've spent at the work. If, for example, Family TV gave me employment here and I was 8 months and a half pregnant, and the next perhaps 15 days I should be going for my maternity leave. Don't tell me you've just come, therefore you can't take maternity leave. No. The right to maternity leave, every female employee has a right to 60 working days. And when I use the working days, we do not put in public holidays. When we are counting those days, we don't put in weekends when we are counting those 60 working days. Unless my work schedule, if I work 6 days a week, that is my normal day of work. If I work 6 days a week, then it means that when I'm counting also my 60 working days, I will use the six days rule. But if I work 5 days a week, when I'm counting my 60 days, I will use the 5 days rule. And should there be public holidays, okay, around in those days as I'm counting them, those ones will remove them. So this leave is for the mother to heal. We have well-documented health benefits of a mother to heal. But you find that some employers actually don't allow these mothers to go and heal. They are forced back. We've had cases where a teacher is forced back after 2 weeks to come and stand in front of other young kids to come and teach. So it is very important that you take your leave. And if such a leave is not given to you, you should be able to claim for your right. The other right that we have a right to we have a right to when I'm talking about maternity leave, I go back to the fathers, because they may say, how about us, the fathers?
That's very important.
Yes, they also have the paternity leave, but the fathers, they only have 4 days. You expect the father to go and support the mother in the hospital, and if the mother has given birth normally, in most cases, within 2 days, you're discharged. But if she has maybe not been fine, maybe sometimes we encourage the fathers to use part of their annual leave. This is something that you've been seeing growing. Plan and say, on top of my 4 days, I should add on maybe like 5 more days, so that you take like 10 to support, this mother. But just something to note about the paternity leave. So the father has 4 days in the year. So even if you're a Hajj, okay, and you have, let's say, 2 of your Hajjats they're going to give birth in the same year. You cannot say you take 4 days for each hajat. No.
You take 8 days.
No, you only have 4 days. You only have 4 days. So you have to strike a balance, or use some of your annual leave to go for the other one. So it's only 4 days, and that's what some people have been arguing that it's unfair. But that is a right for the fathers. Paternity leave is also a right to be paid for overtime when I work overtime as a worker. Now you find that the hour, we have 8-hour rule, 8 hours of work, and we have the 10 hour of work. So if someone works 8 hours of work, those are people who do not work in shifts. But if they are shift workers, you can apply the 8-hour rule. So you can work 10-hour rule. So you can work 10 hours a day if you work in a shift. Like, let's say you come in the morning and you work maybe until 5, and then other people come and replace you. They also work maybe trans-night. Such an employer can put a 10-hour rule. But normally the working hours is 8 hours. And should someone work past the 8 hours, then it just becomes automatically overtime. And overtime is, we calculate it using a 1.5 rule. For example,
what does that mean?
1.5, it means that if I looked at my salary, if I say, okay, if looking at my monthly salary, if I divided it across 21 days in a month, okay, maybe you find that every day I earn 150,000. So should I work those extra hours, I'll say the 150 divided by 8 hours, okay? So meaning I should be able to get how much I work for per hour of the 8 hour. So now, should I now start working overtime? I get what I earn per hour, and I say that I earn 1.5 for every extra 1 hour that I work. It is, I get 1.5. Is that how it's supposed to be? I'm trying to get
1.5.
Yeah, that's why I was saying the 1.5. So you get the hour and a half. So if it is maybe per hour, after calculating, I earn 30,000 per hour. So it will be 45. So for every extra overtime hour that I work. So that is something that, and there are people who calculate them, especially people in the security sector, the private sector, the private security guards. They calculate for them. Sometimes what employers do is that they inbuild overtime money, and you are able to say you will be working extra hours, 2 hours every day. So they already on your salary, they show it that maybe you will be earning this amount of money. But it's very, very important that right, if it happens, you should be able to. Right to social security. That's a right, and this is social security is like a part of social protection generally. Most people understand it when we use NSSF. I think that's how the people first understand it. To save as a worker, it's important that you save some. You save for your old age, the age when you will not be able to work. Me and you will reach a point when we cannot be here. I mean, we have aged, and that is it. So that money, the savings in NSSF, is to help to cover you at that age, but also not only at the age. Sometimes we get life uncertainties and eventualities that come in our lives as workers. And so let me say if you've become invalid, like you maybe you got an accident and you can no longer work, maybe you're paralyzed, this money helps you and your family to continue life. So as a worker, they're supposed to deduct from you 5% from your salary, and then the employer puts on that, caps it up with a 10%. So altogether, your employer every end of month is supposed to remit to NSSF 15% of your salary, okay? And when we say 15% of your salary, this is money they're supposed to deduct it before any other tax, ideally. Like it goes on the gross amount of money, not on the net. So it is that. We also know that there are some employers out there who hoodwink, and I allow me use that word. They hoodwink workers. This is how they tell them, no, we will give you your money. You know, this NSSF, when will you get this money? You know, they start hoodwinking you, but this is your money at the end of the day. And it's the only saving as a worker you can ever make. Like I was telling you, like most workers, we are hand to mouth. So, and that's the only saving you make in a month. So don't be hoodwinked by that employer who is saying, no, let me give you your money. They are only using it not to give you that other 10% that they are supposed to cap for you on your 5%. So be vigilant. Go and register yourself, by the way, with NSSF as workers. Whether you are what, now the law changed. Before we used to have that every employer who has 5 employees and above is the one who would go and register with NSSF. Now, since then, the law has changed. Whether you're employing one, okay, you are expected to register with NSSF and start remitting for that particular worker. So, workers, go and register yourself. Give that NSSF number to your employer so that you save with NSSF. It is your money. You should not be hoodwinked at any given. Whether you, by the way, you are a casual worker, whether you are yes, and that's why some people think that just because someone is a casual worker, you don't deduct NSSF. No, the NSSF is that. It has nothing to do with, you know how payee has a threshold that, you know, only people who are earning starting from 230 are the people who are supposed to, you know, to pay that tax of payee. Because this is your saving, it does not have a threshold. If I'm earning 50,000 per month, remove the 5% and add on your 10% using my 50,000 and remit it. Simple as that. So workers, go and register with NSSF, give your employer that is, because it is your right. So that is one of the other rights that we have as workers. The other right, what we have is the right to medical care and compensation. In case someone, if I'm as a worker, I get an accident or injury or a disease, I get exposed to a disease that has come as a result of my work that I am doing, my employer has I have a right to medication, and I have a right to be compensated if that particular disease or injury has left a permanent incapacitation on my body. We look at every worker as a person who is 100%. Bruno, when you are here at Family TV, we look at you as you are 100%. Now, God forbid, should you get an accident in the course of employment, and the course of employment means you are either traveling to work, because we know, Bruno, you always have this show, so we expect that if you got, God forbid, an accident around 7:30, you are coming here, yeah? You are on your way, and it's a working day anyway, so you're on your way here. So that is a course of employment. Or when you leave, when you're leaving and going back to your home, that's why you're still in the course of employment. Or when you're here and something happened that injures you, it's also in course of employment. Or because of the working environment or gadgets or radiations or what, you acquire a disease that we can only attach to the workplace where you are. That is still in a course of employment. So that's what we mean by course of employment. So if you get those either injury or disease during that course of employment I've explained, first of all, your employer is supposed to first treat you until when you're fine. And the maximum months that they can treat you for is 98 months. How many years are those? They're about 8 years. 98 months.
Wow.
Should your disease or injury or what lead you to such a long time? And meanwhile, when they are treating you, they are supposed to be paying you your salary that you would have earned had it not been for this accident or disease that you acquired.
You're pricking a lot of employers.
Yes, I know, but that is it.
That's the law.
That's the law.
Yes.
Yes. And then after that, should that injury or disease leave a permanent incapacitation? With permanent incapacitation, I'm not talking about scars on the body. You know, we get workers who say, see, madam, here, I got an accident, and you see when I have a big scar. We're not talking about the scar. We are talking about, well, I was talking about, like, you're 100%. Should maybe you have two hands now. God forbid, should maybe that accident or injury leave you with one arm. Now you're no longer 100%. So the law has put in place, what should this person be compensated? It is a percentage. So we use a percentage, and there is a formula how we calculate it. Okay, so we get that person, let's say you've been given 60%, so we get the 60% divided by 100 times your salary, your monthly salary you are earning at the time of that accident, your rate of salary, and then times 60. 60 is a constant within the law. So whatever comes out of that calculation becomes your compensation, but that should always come at the end after the employer has treated you. And I want to just tell the workers out there, again, don't be hoodwinked. We have employers who hoodwink workers, but also the workers themselves. We want things, very, very fast. So someone gets an accident, they are still being treated and says, I should be compensated. Ideally, that's not a procedure. The procedure, you first treated, heal, let's see how, because I can get an accident here, and then it is not that it's going to leave a permanent incapacitation on me. I'll be fine and I'm able to do everything, okay, that I'm going to do. And even I tell, for example, employers of domestic workers, I have a domestic worker, and the same law applies to that domestic worker. There's a case we handled where the domestic worker is coming from, I think, Bushen. 2 days at the job, she was burnt with gas. And you know that this assessment is done by doctors, not by lawyers or what. So the doctor, when he was doing this assessment, said, because they also take into consideration the kind of work that you do, okay? Because she had been burnt and like the face had been deformed somehow, the doctor was able to say that this person will no longer do the kind of work she was doing to earn a living. And explained that and said, because in most cases, households hire domestic workers to look after the young ones. No one would want to hire such a person. And you see, so the doctors even give the reason for the assessment they are giving. So any workers, don't be hoodwinked. So some workers are hoodwinked that, let me give you your compensation between them and the employer. No, there's a process. It even involves the labor officer who makes the calculation after the doctor has assessed you. You take the assessment form to the labor officer of your area, of your district, of your division if you're in Kampala, of your municipality if it's a municipality, and then that labor officer calculates using the other formula I've told you. Then they write, there's an order within the law, the Workers' Compensation Act, which they serve on the employer, and the employer is supposed to use that to compensate you. Something else about workers' compensation on this right. We have, employers also pass on a risk, okay? And it's allowed because even the Workers' Compensation Act tells the employer that they should insure themselves against liabilities, okay? So the employers get insurers, okay, for their workers and for such liabilities. But insurance companies, they always have a tendency of getting doctors, and then the doctors always reassess these workers. An insurance company, they have no right. If someone is watching, they don't have a right to reassess a worker after the doctor who has been working on this worker has made an assessment. If the employer is disputing this particular percentage that has been given to this worker, the procedure is that this employer writes to the labor officer of the area, and this labor officer forward this matter to what we call the Labor Arbitration Board. Now, the Labor Arbitration Board sits here in the Ministry of Gender, Labor and Social Development. It has experts on it that reassess this worker about the permanent incapacitation, and they give the final assessment, but not the insurance company. So insurance companies and the Insurance Regulatory Authority kindly help us with your members, because they are doing a lot of illegalities. When it comes to workers' compensation, they don't have any right under the law to do that. So those are some of the rights that accrue to a worker. The right to work in a safe environment, the working environment where they work, it should be safe enough. First of all, it should be having drinking water, for example. It should be having washrooms for both, if it's possible, both male and female, because when I'm at the workplace, I should be able to feel comfortable. Some people ask me, Lydia, don't we have a right to food? No.
But if you have a right to drinking water and you don't have a right to food, there's an imbalance there.
No, water is water is life, okay? And it's something someone should be able to access. You can, in our society, you can just branch even to a neighbor, even if you're just walking and you feel thirsty, and you just branch and say, can I have some drinking water? And that should be given. But you can't branch and say, can I have some food? That normally those two are different. So the right, safe drinking water, washrooms, proper sitting place. The area should be well aerated so that people are able to get oxygen in. Should not be congested. If there is machinery, the employer should be able to clearly earmark the machineries that are dangerous, which areas, what gadgets I'm supposed to have for me to access such a place. So the safe working environment is also a right to this particular worker. The last one is, of course, to be treated in a humane manner. Before anyone is a worker, they are human beings. And every human being, they should be treated in a humane manner. Now, those are some of like the rights. I would also love to talk about the responsibilities, because the viewers there, the employers may say, oh, today Family TV has just come
for us.
Bombard us with these rights and rights. But no, in this relationship, like I said, once there is a relationship of the employer and employee, there are rights and there are also responsibilities.
And we shall get into the responsibilities later on, and we shall also be talking about child labor. Thank you for joining us. Employers, don't worry, I know many of us have been pricked, but this is according to the law, and we're going to find out the responsibilities of of employees, as well as how feasible the implementation of these rights are, especially in Uganda today, where we find there high levels of poverty and high levels of unemployment.
Yeah, thank you, Bruno. I'll start with the responsibilities. To our dear viewers, the workers out there, we also have responsibilities at the workplace. The first responsibility, again, it starts from the relationship itself. Work and you're paid. So we said you have a right to be paid. But the first thing is you must what? Work. So the first responsibility of any worker, for you to do the work that you set and you agreed that you are going to do. Do it in a manner that has how you have agreed with your employer. Do it in a manner as in that profession that it is required of you. You know, because some people are professionals in their being. The employer may not be a professional. Let me say, if you are an accountant, for example, the employer may not be an accountant. So we expect that as an accountant, you are going to do that work of accounting in the profession of accounting as it is known. So the responsibility to work is a must, because you first work and then you are paid. So you see, this right to be paid has a responsibility first to work before you are paid. And as you are working, do you work diligently? There are some workers who just work to finish. No, that is not what we are referring to. As a worker, you should be able to do your work. So that's one of your first responsibility as a worker. The other responsibility as a worker is to adhere to the rules and regulations. Now let me rephrase it. To adhere to the lawful rules and regulations of that workplace. I had to put lawful because my employer should not ask me to go and kill, because that is an order, okay? And I go and kill. No. Or should not be that my employer asks me that on top of your working, I also want something else. This is sexual harassment. That's why I had to put lawful rules and regulations. So for those, you have a responsibility to adhere to them, because every given workplace, we have the national laws up here that govern both you and the employer. But that given workplace also has a right to set up its own rules and regulations. For example, where I work, we report to work by 8. Okay? So that is a rule. It is not in the law that you should report, but at least the employer should determine when you should report and when you should. Out of those 8 hours. Yeah, out of the 8 hours. Or out of the 10 hours, exactly. So adhere to them. And if you have any challenge of that 1 day or 3 days not being able to report accordingly, communicate to your employer. Seek for permission. Some workers, they say, in Uganda we like burying. When people die. Because we are community setting as a country, as a people. You know, what affects my neighbor, what happens to my neighbor affects me. So we always console one another. And that also we carry it with us. Even as we are employees, for example, we remain part of the community and remain part of our families, remain part of our bigger clans. That is okay. But as you do that, please don't forget that you also have work. And at this workplace, they are not part of the community, they are not part of the family, they're not part of the bigger clan. So don't, if you are to bury kindly, I encourage us, bury responsibly. Be responsible enough. You can't bury today 2 days, the other day 5 days, the other day 6 days, the other day, you know, continuously you're burying. When are you going to work? When are you going to fulfill your responsibility? Then at the end of the month, do you expect to be paid? Because you have not been working. So why they bring it like that? Some workers, they say, why didn't you report to work that day? I had gone to bury. My neighbor had lost a child, I had to bury. Whereas it is human that you went and offered consoling support to your neighbor. It is also human that you ought to have considered also your employer. Did you seek permission? Okay? Did they allow? And if they give, some people, they give them permission and say, okay, go and bury for 2 days. They spend 4. So when they come back, when they have been declared absent or they have been absconded from work, those people are inhuman, especially us workers. Again, let me come to us workers, especially Ugandans. I'm going to speak to us Ugandans. We are always complaining about our foreigner employers. They are harsh, they are what? You know, they don't allow, but they have given you at least 2 days that you go and bury. You want to spend 5 days. Doing what? Would a person come back? I always ask that question. It may sound insensitive, but it is true. Unless this is maybe someone, a child, a mother, a sister. Those ones, even the employers, in most cases, they have policies that also speak about those people. That if you've lost maybe a child, maybe we'll give you like 4 days or 5 days. They are also understanding. But you're going to bury a clan brother. You want to spend 6 days burying. So we need to be considerate when we are going. So communicate, adhere to the rules and regulations. As an employer, you also have a responsibility not to endanger the working environment for you, for the employer's property, and for your fellow workers. I should not come here and start setting, if they say no smoking is allowed here, and I come with my smoke, and I start to put, meaning the place may burn down. So I'm endangering the what? The workplace. As a worker, you're supposed to cooperate with your fellow workers. It's a responsibility, and your employer. You know, when I talked about the right to annual leave, I said this right you should be able to speak to your employer so that you take it in a cooperative manner. Okay, this one will be off. You don't leave a vacuum. Okay, why cooperate? Because you're working as together with other people. So we expect you. Don't be the one causing problems at the workplace. Some workers are the people who cause rumor mongering, causing chaos amongst workers. You know, being that they know I know more. No, don't do that one. Don't do that. You're setting the employer, other workers against the employer. So that is not your responsibility. It's not even part of your JD, your job description. I mean, that you should go and start being kayungirizi in a negative manner. Sorry to use that word in those things, but we have those instances of workers who are problem setters at the workplace. So you are supposed to cooperate. Don't set people ablaze. Don't be the person causing chaos at the workplace, because the workplace is supposed to be like, you have a right to a conducive working environment. Do not set it ablaze to become non-conducive, to become chaotic for others. So there are some of the responsibilities of our worker,
of an employee,
of an employee.
And when it comes to you spoke about some of the during the break, we were talking about one of the issues we have here when it comes to workers' rights in this country is the issue of poverty and unemployment. That it creates a situation where there is a desperation, and people are desperate to get jobs, and they overlook workers' rights so that they can get these jobs. Can you touch on that briefly?
Yeah, of course. We know that as a country, we are one of the very key development challenges that this country is faced with is the high unemployment rates. And also, of course, poverty. And with the pandemics and the epidemics, all this is a mixture of it. And therefore, looking at right now, the economy was trying to recover. Then we are struggling with here now Ebola. So the rate of absorbing people into the working category is very low. So because of that, we've seen that some workers are willing to compromise on their rights so that they are able to have something to work and something to earn from. But that does not mean that that is the right way to do about it. It doesn't mean, and let me tell you something. When a workplace respects workers' rights, the productivity of that workplace, the workers, their productivity is very high. That is a given. When the workplace respects their rights, working employment, labor and employment standards, the productivity of those workers in that workplace is high. The retention is high. Let me tell you, as employers, you lose. You lose how? If, just imagine that all the time you're in courts of law, because then you need people like us, you need lawyers like us to represent you, isn't it? So you have people on a retainer. You're paying them money. You're losing money. To retain a lawyer to be dealing with, why you wrongly dismissed this one, you did not give this one leave, you didn't do this one, you didn't do this one. You're losing money as an employer. And yet, if you adhered and gave this person these rights, then they will not have anything to complain about. Not that they will just be concentrating on their what? On their work. And as you, as an employer, you will be gaining from their labor at the end of the day. So I call upon employers to try as much as possible to comply with these rights, to comply with the labor and employment standards. Because at the end of the day, by the way, if you look at it with a longer lens, the employer benefits. It is for the benefit of the employer to comply with those rights. When you cheat a worker, just know you will be cheated. That is a given. The worker, either they will do shoddy work, okay? Either they will cheat on you. For example, I can sit here, I can actively have a computer in front of me when there is no deliverable at the end of the day. But you are seeing me and you're paying me. So I'm cheating you as a worker. So the moment, at the end of the day, what I'm telling the employer is that don't so much look at, if I'm to comply with these standards, I am giving them a lot of liberty. No, you are actually doing yourself a favor. You will be out of court. You will not be in labor office. The time you waste writing, responding to emails from labor officers, from court, then you have to go and give testimony. That is money. You're losing money as an employer. So you don't need to be in that. Adhere to them, set standards for procedures. And I'm not saying employers should not terminate workers when they have reason to terminate, if I'm unable to pay you, but let me use the right procedure. Okay. So whereas we have this poverty and unemployment, where workers are being forced to compromise on their rights, employers, don't use it as an option, because you're cheating yourself. You made work which you can, let me say 10 people can deliver on, you employ 30. Because you are paying them very little, and they also give you little output because you pay them little. You understand? Everything at the end of the day, if you look at it critically, you lose as an employer if you do not adhere to these labor and employment standards. That's
definitely. And unfortunately, when we're having a good conversation, time catches up with us.
Yeah.
And but very quickly, I'd like you to address us on child labor, what the law says about child labor, and then end with giving us your remarks on how a worker whose rights have been abused can seek redress.
Okay, so thank you so much. Child labor. So these workers, the children, the Employment Act of Uganda, under Section 32, talks about employment of children. But which children, which ages can be employed? First of all, a child of 12 years and below, they should not be employed in any form of employment or undertaking anything. Why? Because by the design of the government programs, 12 years was that this child should be completing their P7, and we have what we call universal primary education as a government program, meaning every child is entitled. And now even the government has gone on to bring on board the universal secondary education. So that means that is even increasing the age at which a child can start being employed. But the Employment Act also states that a child of 14 years can be engaged, okay, in light work under the supervision of an adult. Now, most people, we've seen people who are sending children to come and hawk on the streets of Kampala, streets of Jinja, streets of wherever the country. No one is supervising those children. And moreover, on the streets, it's very dangerous. That is harmful child labor, because you don't know how, if the child knows how to cross the road, or they will knock the child, or, you know, anything can happen to this child. Another thing also what happens on the streets here, just here in Kampala, I'll give you an example. For the vending, you know, those girls are raped. Yes, they are raped. Some people either by fellow children, defied would actually been raped. They are either defied by fellow children or even adults within the city, the cities. How? They say, you come, now she's carrying, let me say, bananas, okay? You come, I'll buy for you the bananas. Where they take them, you do not know. So there it exposes them. So even if a child of 14 years may be employed in light work, and by the way, this light work is supposed to be a work which is supposed to help them for their development, for them to grow as responsible people. Like, you know how to look after yourself, you know how to make yourself a cup of tea, you know you can sit, and if it's a shop and my mom is there and they say, a customer comes and say, give me sugar, I'm able to measure the sugar on a washing machine, that on the weighing machine. So that is work that is not harmful. I went to school, I was just sitting there with my mom and I'm just serving a customer. That is okay. That work has not interfered with my education as a child, is not interfering with my development as a child. It's not interfering with my moral development as a child, my physical development, and my mental development. Instead, it is helping me to know, okay, if at home we sell, we have a shop, and we sell, this is what we sell, I can also sell this thing. So basically, that is work. But of course, the numbers of child labor have doubled as we speak. Since COVID-19, we moved from 2 million now to 4 million children into child labor. So the trend is growing, but it's a responsibility. The work is no business for a child. Their business is at school. Let us as parents try as much as possible to put these children in school. Try your level best, because education is the only thing you can give to your child and will never be taken away. Don't say you are building mansions and what, they can be taken away at any time, but education, they can always prepare for themselves, whatever they want to have. So I call upon parents out there, please, and employers who employ these children. I wish I had time. Bruno, you should invite me again. I speak about just child labor, because I always want to talk about even the private sector that employ these children. We are seeing growing sections of child labor in sugarcane sectors, in rice growing sectors, in coffee, and these are big sectors of the country that are contributing to the GDP. But we see that child labor is taking place in these particular sectors. We need to invite me, speak about what are the responsibilities of the private sector when it comes to this issue of child labor. Briefly, as I can talk about, but my parting shot is, first of all, if you work out there and your right has been violated, or you just want even just seek advice on what to do, you can reach us as Platform for Labor Action. We have offices in Kampala. We have offices located in Ntinda, Plot 14, Matters Lane, as your slope to National Council of Higher Education. We have offices in Eastern Region, that is Iganga, near the Electoral Commission offices in Iganga District. We have offices in Lira, near the RDC's office. So please visit those offices. You'll be able to be supported. But I can also give you a number that you can call on the office line in case you have a need for our services. So it is 0393 196. I can repeat it, 0393 290 196. You can call on that line and you can get us. You'll be able to be supported. Thank you so much, Family TV, for inviting us.
Thank you so much, Ms. Bwiite Lydia, for taking us through workers' rights and the issues that encompass that, and that's things like child labor, and we have learned so much. And again, definitely we'll ensure that you're back so that we can discuss the issue of child labor properly, so that we all learn and understand. Thank you so much for joining us on Issues at Hand today, and we continue to bring you interesting discussions tomorrow. For now, ciao. God richly bless you.